So, in thinking about the standard of care, I hadn't missed the diagnosis. I hadn't rendered improper treatment in my mind. I hadn't failed to admit the child. My failure to admit the child didn't fall below the standard of care. Certainly, there was some damages, and the injury had caused the problem, but I didn't think it was due to my negligence. There was a problem, and it had to do with documentation. ER forms in those days, it was a one-day form. Now, I'm a compulsive documenter, right? So I filled up all of the space on the form with all of this really good information about the range of motion and the tenderness and the x-rays and all of this stuff. And I'd even written down my recommendations, but what I didn't write, because I ran out of room and I was too lazy to walk 20 feet to get another sheet of paper and sit down and write it down, I had failed to document my conversation and instructions to the father. In those days, we didn't have instruction sheets that you give to people for every little sprained finger and wound care and this kind of stuff. It was up to the doctor to do it, and I looked the guy right in the eye, and I told him what I thought, and I thought he was going to do it. So, trouble. Documentation, this is the fine little lines that legal cases depend on, and that's the trouble in this situation. Well, then I started talking to the insurance company, and what do they want to do? And of course, they talked about settlement. We talked about trying the case. We talked about defending it if I insisted on it. My experts kind of told me that the documentation was an issue. I needed to think about that. My attorney alerted me to the fact it was that. And so it boiled down to, what do I want to do? And my concern was that if I didn't get out of this case, I might be in it for $400,000, $500,000, $600,000 out of my own pocket, all of which I didn't have as a retired military officer and a newly employed staff position at the Mass Eye and Ear Infirmary. Sorry, Joan. Right. So what if your financial responsibility exceeds policy limits? Well, one of the things that you can do, and what I did, was to write a letter to my insurance company to instruct them to settle at policy limits if possible. And I did this as a protection upon the advice of my private attorney because it puts the insurance company on notice that I really wanted to try and get this case over with if I can. What were some of the concerns that I had about taking it to trial? Well, I had a personal feeling that there was an element here where I had failed to meet the standard of care, and I'll come back and talk about that in a minute. I knew that I had a problem with documentation. The case was a child. That's always a bad sign. There were significant damages, and I had personal risk at financial exposure, and I kind of felt like I wanted this case over with. Well, what about this standard of care? I had already mentioned that as I reviewed the case, I had done everything that I thought I should do and that I had met the standard of care. But as I got to thinking about it and reflecting on it, and believe me, I munched over this for a long period of time, I really felt that I had failed in my duty to communicate with the father, and that that's part of the standard of care. For instance, Mom was available. If I'd gone out to the emergency room and brought her in, she was probably much more likely to take that child to the to their family doctor on Monday than was the father. And so, in a sense, I kind of felt like I had not lived up to my duty as a physician in terms of communication with the family, and that might come up, and it bothered me for a long time. So, the next question is, how does this experience affect me as a physician? Affect my behavior as a physician? Well, there's good data on this. Following a medical malpractice lawsuit, choose from one of the four. Physician's performance improves. Physician's performance is unchanged. Physician's performance deteriorates. There is an increased risk of second litigation within 12 months of receiving the first claim. As a matter of fact, there's an increased risk of second litigation within 12 months of receiving the first claim. Why is that? Your mind is distracted. You sometimes there may be something that was going on in your life that took place with the first suit, and it's still going on in your life, and you have a second or a third suit. And we see these clusters in OMIC all the time, that we will see a person who practiced great for 10 years, and then 2 or 3 claims pop up within 18 months. I've been surprised because with the first 3 answers, it's all over the place. You're quite correct. Sometimes physicians' performance, and many times it does improve. Sometimes you would think that it's improving, but it doesn't really improve, and then there are a few people that just don't seem to do much of anything. So there are changes in behavior, and I experience these as well. In a large series, 70% kept more meticulous records, 60% ordered more diagnostic texts, half of them stopped seeing certain types of patients. Surprisingly, almost 20% reported feeling a loss of nerve when it came to handling cases in the future. Now, it might have been for a short period of time, but there are reports of physicians who could not practice anymore because of what they had gone through, and they just lost confidence in themselves because of that. And that's a shame, because people have gone a long way towards their education, and to lose that, I think, is a big loss. A third, entertain thoughts of early retirement.